County Planning Commission. Today is November 2nd, 2022, and today's meeting of the Planning Commission is called to order. Will the clerk please call the roll?
Yes. Commissioner Havner,
Present.
Commissioner Milliman. Heard that she might be having some technical difficulties logging in, so she might chime in a little later. Commissioner Bidu is absent. Commissioner Petrillo. He's not in, but he did say that he would be present. Commissioner Podar is absent. Commissioner Wellner.
Present.
Commissioner Will.
Present.
Vice Chair Dye. He is logged on.
I think he was going to go away for a moment and then come back.
Okay. And I see that Commissioner Milliman has joined. Commissioner Milliman, I was just going through the roll call.
Present.
Chair Lockwood.
Present.
Okay, so it looks like we have 1, 2, 3, 4, 5 in attendance. So we do have a quorum.
Thank you. All right, let's go ahead. Director's report.
Thank you, Chair Lockwood. For the record, my name is Erin Wardell. I'm the Interim Planning and Development Services Manager for Washington County, and I have the Director's report. So starting out, as we discussed at our last meeting, the Planning Commission meetings will continue to be held virtually for now, but we would like to work towards having an in-person or hybrid PC meeting in February of 2023. The intent of that is that we would have 2 new planning commissioners appointed at that time, and we can also acknowledge our outgoing members. Speaking of that, the recruitment for those vacancies continues. So staff sent an email on Friday, October 18th to all of you about that recruitment and asked for your help in sending it out if you know anyone who may be interested. I know at least one of you has done that, and we really appreciate that help with the recruitment. If you have any questions, please reach out to Todd Borkowitz with those. We do have a board work session scheduled on the recruitments for January 3rd of 2023. So at that time, we will share potential nominees and information about them with the board and then go back to get the board's direction on appointing 2 new planning commissioners at that time. Changing topics, yesterday, the Land Use Board of Appeals, referred to as LUBA, heard oral arguments on the Leahy Estates appeal regarding application of the county's significant natural resources regulations. LUBA indicated yesterday that their decision would be issued by November 21st, so we should see that shortly. Staff expect to have more to report in January about both the appeal and other legal challenges. We also are continuing to work on the selection of a consultant to do the technical work on updated regulations that we'd like to do. So again, we'll have an update on that in January. And if you do have any questions, we have County Counsel here, Rob Bovet, who can answer questions about LUBA yesterday. Coming up for next year, this feels like a ways from now, but I think April of next year will be upon us before we're ready for it. We did confirm that the Fair Housing Council of Oregon will be available to do a 2-hour virtual training at the April 5th meeting, and that will be a joint event with the Beaverton and Hillsborough Planning Commission. So I'm excited about that. I think it sounds like a really interesting event, and I like the idea of joining in with our neighboring planning commissions. We continue to address feedback that we've heard on challenges with our new county website. I will say that I think over the last couple of weeks, we've made quite a bit of progress on updates and fixes as they've been identified by staff and also by community members. So since our last meeting, you can now successfully search for the Planning Commission from the county's main webpage. You can also find it from a Google search. I tested that yesterday. And we have now our PC landing page set up. You received communication about setting up a time to have your photo taken and your draft bios that will go on that webpage. So please reach out to Todd if you have any questions about setting up your photographer appointment to get your picture taken. We are offering that either here in Hillsborough, or we can meet you at one of the Beaverton County facilities if that's easier. So we can discuss that a little bit, or again, reach out to Todd if you have any questions. For today's meeting, you will be having your second hearing on ordinance number 889. That's the minor amendments to the Community Development Code. And you'll be having your first hearing on ordinance 890, which is the middle housing land division amendments to the Community Development Code to implement Senate Bill 458. For our upcoming meetings, we have a November 16th evening meeting on the calendar. If needed, we'll come back for a second hearing on ordinance number 890. We could have a work session item on the website updates if that's something you're interested in. We also could talk about some other work session items if there's something of interest out there. So for the December 7th, December 21st, and January 4th meetings, we don't have anything that we're expecting. That could change based on how things go today, but we don't expect there to be topics for those meetings. So we recommend canceling. And I know schedules get really complicated around the holidays, and so that's something that we're open to discussing, but at this time we're recommending canceling. And then coming up for January 18th, we expect to have a work session update on the significant natural resources. So that is the director's report and upcoming meeting summary. Any questions?
I'm not seeing any hands up.
I have one. I don't know where my hand
Oh,
is.
go ahead. Go ahead.
Yeah, I have a question about what is the status of, maybe I didn't hear it, I joined late, but the work plan, the county work plan for department.
The long range planning work program.
Correct.
We are taking the brief update to the work plan to the Board of Commissioners at their meeting next week as an action item. And so we expect them to authorize us to do the continuation of activities we already have underway and possibly file ordinances related to state mandates. We then expect to kick off the larger work plan conversation early next year, so that we'll go through the full update with community engagement process at that time.
So we did have a work session with the board on October 18th and went over a staff report that was similar to the one that we gave the Planning Commission a couple months ago, essentially saying that we're continuing to do a lot of the work that was already in the work program. And then we had some items that were coming down as state mandates or otherwise were things that we felt we needed to do right now, that we couldn't really add things at this point, but that we would start talking with community members and doing the kind of standard process that we have done, but do it for a 2-year work program starting early next year. So the board did give us general direction that they agreed with that approach, and that's what we're going back with for them to take action on next Tuesday.
Thanks.
Any other questions for Ms. Wardell? Okay. Thank you very much for the presentation. Ms. Aguilar, do we have anyone signed up for public communication?
No, no one has signed up in advance. Would anyone in attendance like to communicate to the Planning Commission on non-agenda items? If so, please indicate by raising your virtual hand. Seeing no one, we can move on.
Okay, thank you.
Oh, excuse me. It looks like somebody raised their hand. Let me see who that is. It looks like Jody Dehen.
Yes, that is correct.
Okay. Please go ahead, or Chair Lockwood.
Yes,
Is she
please go
okay
ahead.
to- Okay.
You were asking for one of us to inform. I need a repeat of the question. Show me.
Maybe we need to confirm that you're not addressing either of the ordinances for today. It's another topic. Is that right?
Oh, no, I'm so sorry. I misunderstood. We're purchasing a lot in unincorporated Washington County, which is why I'm sitting through this today. And we have for 2 months been trying to obtain how to build it out either in Washington County or City of Cornelius, because it's on the urban growth boundary. So I apologize. It's been so painful trying to obtain information about it. So I'm listening today and I apologize. I thought it was having to do with this ordinance 890. So you can remute me. And
Okay, so you'd like, I just want to make sure you'd like to testify during the public hearing that relates to ordinance 890. Is that right? I think she's muted again.
can you hear me now?
Yes.
Okay, sorry, I've not done this before. So testifying is in regard to, I've just never done it before, so I don't know
That's
how to. But
fine.
I've obtained an enormous amount of research from both sides, Washington County and City of Cornelius, but it's just been really painful to try to understand how to develop this lot of land we're purchasing.
So I'm just trying to understand. It doesn't, does your testimony relate to 890? Or
when you say testimony, I've never done this before, so I'm asking for some guidance. When you say testimony, do I bring to the table information I have, or I've just not done it before? So I'm wanting to become involved, but I've not done it before. So I'm just asking for
it sounds to me like your testimony is not specifically about the ordinance, but about your situation. Is that right?
Well, actually, your ordinance 890, I read it in completion, and it is missing some accurate process for the cottage cluster aspect.
Okay, so you'd like to testify specifically about that ordinance.
Yeah,
correct?
on 606-10B.
No, wait just a moment, please. Yeah, so what I'm trying to get across is that this time right now is for issues not related to the ordinances. Later, we'll have the hearings on the ordinances, and then if you'd like to speak about ordinance 890, that would be your opportunity.
Okay, and when will that be? Today and today's, or
It'll be today.
Okay. Okay, I'm just trying to get some clarification. And
that's fine. I'm sorry if there was.
Go ahead and remute me then.
All right, thank you.
And Chair Lockwood, it looks like we have Matt. Forgive me if I say your last name wrong. It's Spray. But he also has his hand raised.
Yeah, it's Matt Sprague, and thank you, commission members and staff. I just wanted to provide a clarification. I originally signed up to testify regarding 890, and I sent in a letter, and I think my testimony is more relevant to 889, and Nikki Munson with Riverside Homes is also signed up to testify in 890, and I think it'd be best if you guys would push us on to 889, because that's where our testimony is more relevant.
Okay, we can certainly do that. So is there anyone else who's wanting to speak to us on matters not relating to the, no,
not at this time.
okay, thank you. Then let's move on to our public hearings, and the first one will be on ordinance 889. May we have the staff presentation, please?
Thank you, Chair Lockwood. Good afternoon, Planning Commissioners. I'm Karina Rendies, Associate Planner with Community Planning, part of the Long Range Planning team here at Washington County. I will be presenting the staff report for the second hearing on ordinance number 889, which makes minor amendments or changes to portions of the county's comprehensive plan. This ordinance makes changes specifically to the comprehensive framework plan for the urban area, the Bethany Community Plan, and the Community Development Code. However, today's hearing will focus on changes located in the Community Development Code, or CDC. Next slide, please. So in this presentation, I will go over the context for the hearing, which, as I mentioned, is focused on CDC changes specifically related to easements. And so as part of this presentation, I will be providing additional information about easements, going over some scenarios about when we'd like easements to be used and when maybe there are some gaps in our code, and how we're proposing some changes that we might need to continue to work on to ensure we're meeting all of those potential scenarios, as well as a staff recommendation for your consideration after this presentation today. Next slide. So to start with, the reason for this hearing, concerns about proposed amendments to maintenance easement requirements were identified the last time I came before your commission on October 19th. And at that time, your commission did ask for more information on the topic and continued the hearing to today. So no decisions were made on October 19th. And now you'll be considering new information and some potential proposed new language in order to be able to make a recommendation today on the engrossment of ordinance number 889. Next slide. So let's take a step back. What are easements exactly? So they are legal instruments that convey rights, typically the right of someone to access property for a particular reason, such as our, access for right-of-way, for travel. There are also maintenance easements that are provided in order to ensure that people have access to neighboring property if they need to make repairs or maintenance to the sides of their buildings. And we adopted maintenance easements as a requirement when we adopted a package in 1989 over 1998 of a variety of different changes that were made to accommodate construction of detached dwellings on smaller lots. So we were looking at reducing the minimum amount of yard size that applied, and we started decreasing those side yards. Next slide, please. So when side yards are decreased less than 5 feet, we, at that time, determined that it would be appropriate to provide maintenance easements. And this is to ensure that all property owners are going to have adequate space to perform maintenance on the side of a dwelling. So the current standards are written so that these easements apply specifically between buildings and only when buildings are less than 10 feet apart. The filed ordinance was intended to propose some changes to require easements along the shared property line, regardless of the distance in between dwellings. So next slide, please. So here you can see how our current standards work. The layout on the left is kind of the standard configuration. Each of the lots have reduced side yards to 3 feet, and altogether 6 feet of space is provided in between the buildings. And that works for that standard layout. It doesn't work so well when the dwelling frontages are staggered. So then there are portions that might require maintenance, but they're not strictly in between two of the buildings. Next slide. And then this is the other scenario where these don't work very well. And this is when the location of the placement of the dwelling is kind of offset, meaning in some cases, such as shown here, no easements are required at all, despite the fact that the dwelling on the left would probably need to conduct some maintenance where there's only that 1 foot setback. So these are the kinds of scenarios we were thinking about and we wanted to address. Next slide. And we thought we knew what we wanted, an easement that applied regardless of the distance between dwellings, as well as when building frontages are staggered. But as the language was written, it was focused on the property line, and this was an unintended consequence. This is more area subject to an easement than we had actually intended. So we do recognize that the issue that planning commissioners brought up at our last meeting was something that needed to be addressed. Next slide, please. So again, there are a number of scenarios that these easements need to cover, whether the dwellings are offset or staggered or both. So this is kind of the original intent of our change. Next slide. And we also know where side yard reductions really shouldn't be allowed. And so that's this scenario here, where really there shouldn't be a reduction in the side yard setback because they're on the other side of that property line where there's an open space tract, or what's really common in our urban areas that this is going to be a tract preserved for clean water services use to provide a stormwater facility, and those are fenced and they're limited access for liability, among other reasons. So this is one of the scenarios that we need to be contemplating when we're talking about these access easements. Next slide, please. So we did propose changes to the filed ordinance and the staff report last week to address the unintended consequences that the planning commissioners identified, as well as trying to get at solutions to address our original concern. And that language would apply maintenance easements where a primary dwelling is located within 5 feet of a property line. And it was written that way so that it would not scoop up accessory structures or accessory dwelling units that have their own setback standards. And we also thought that this change would ensure that the easement was located along the length of the dwelling, not the length of the property line. Next slide. However, upon further review, we identified a need for some additional changes to ensure that all of the scenarios are addressed. Additionally, developer input and further staff analysis revealed some overlap with this issue, Ordinance 889, and the issues being addressed through Ordinance number 890 for middle housing, which is the next item on your agenda today. In particular, we have kind of overlaps where we are addressing the same code sections in very similar ways. And because of this, we are recommending that the proposed changes related to maintenance easements that are currently contained in Ordinance number 889 be removed through the engrossment process, which would then mean we could address this issue with ordinance 890 and make sure that we're taking a comprehensive look at how changes in one part of these requirements might be affecting the changes that are being worked on in another ordinance. So next slide. So right now we are recommending the following changes be made to ordinance 889 as filed. And these include those we discussed at the last meeting, as well as the issue that brought me here today. So as a reminder, the issues at the last meeting included adding chairs of the committee for community involvement committees. So that would be the CCI committees to the CCI membership, and that would be to address comments we received from a CCI representative. Also discussed at the last meeting were provisions for land divisions, and we wanted to revise those for consistency with statute and add a cross-reference there. And then the new recommendation we're making today to remove changes to maintenance easements from ordinance number 889, and we'll fold those into the work that we are doing on ordinance 890. Next slide. So staff's recommendation for your commission today is that you conduct the public hearing, and then at the close of the hearing, recommend approval of this ordinance number 889 to the Board of Commissioners with engrossment to revise the provisions for CCCI membership as shown in attachment A of the staff report, as well as revising provisions for land division, also shown in attachment A of the staff report, and then removing proposed changes to side yard setback and maintenance easement language in CDC sections 304 through 309. And with that, I've concluded my presentation, but I am available to take any questions you might have.
Are there questions for Ms. Arendes? Commissioner Wellner. I think you're muted.
Sorry. I think I need a preview of ordinance 890 before I can vote on ordinance 889. I guess, I understand what it is you're doing, but can you give me some idea of what the added complexity is that we're going to be addressing in ordinance 890 relative to this setback issue?
So there's overlap with middle housing in that there were provisions to allow reduced setbacks to the R5 and the R6 district through middle housing. That was a new change that created some overlap that needs to be addressed. We also want to make sure that the language for the easements does adequately identify who's benefiting from the rights and who's doing the conveyance between different properties. So there are some legal things we want to make sure we get right, and there are some things that we know were affected by middle housing, and we want to make sure that we're looking at that kind of holistically.
So, and just a little bit more on that, Commissioner Wellner, the additional issue with the middle housing regulations has to do with a reduction in side yard setbacks that's allowed with standard land division that is applied slightly differently with middle housing, and is creating some problems when there is a a further land division that includes several of the new middle housing lots. And so we have been talking with at least one developer representative that's having issues with this. And we are proposing some changes to address that issue. So that then means changes to the same sections that were being amended in this ordinance. And we really can't have two ordinances that are making changes to the same code sections. So our thought was that we should move it to one of the ordinances and comprehensively look at it and deal with it there. And since Ordinance 890 has a couple more weeks of time to work on language than this ordinance does before it has to go to the board, we thought to move it to that ordinance, to Ordinance 890. So it would include all the things that Karina's working on, plus this other middle housing issue with reduced side yard setbacks for middle housing.
So are you asking for just an initial hearing and a continuance? Or because I didn't see in the packet any proposed language specific to that section in the 890 ordinance.
Right. So we'll be going over that in the next presentation. We have some specific potential language for one of the changes. And for one of the changes, we have the concept, but not the specific language. So it will depend on the Planning Commission's comfort level. I think once you hear the presentation and what the recommendation is, whether the Planning Commission would want to continue it or not.
Okay, I have one more if that's okay, Ms. Chair.
Yep, go ahead, please.
So on page 4, I think Corrine already referenced this, but on page 4 of the staff report, it references the CDC sections that are affected by the change being made in this language, and it references R9, R15, R24, and R25 based on those code sections. I'm assuming what you're saying is we need to add 302 7.1 and 303 7.1 to that list.
That would be correct.
Okay, that was something I was gonna raise today, so thank you for that.
Commissioner Milliman. I'm wondering if we lost her. Commissioner Will, why don't you go ahead and then we'll come back.
Thank you, Chair. My question is for staff and just a clarification on the staff report statements, and we're on the perfect slide 14. There at the bottom bullet point, it says from sections 304 through 309. And in the October 26th printout I got, it just shows examples of 304 on page 4 of the staff report. And then in attachment A, it shows 304. So it doesn't show the other ones. But I just want to make sure that's clear. It's 304 through 309, even though the page 4 of the staff report and the attachment A is only showing like an example. It's list 304 through 307 in the staff report, attachment A, gray bar.
So that is correct, Commissioner Will, that the language repeats in sections 304, 305, 306, 307. So rather than providing the same language over and over again, we just showed in the attachment that these are the changes that are going to be made for middle housing side yard setbacks, and then these would be the changes that would be made for non-middle housing side yard setbacks. And if the commission does go with staff's recommendation, that would be the material that would not move forward with ordinance 889, but would instead be folded into the next ordinance, ordinance 890.
Yeah, And just to clarify one more time, if you go to attachment A on page 1 of 3, there's two sets of text in like a gray bar. The second set of text says 304, 305, 306, and 307. It doesn't list anything after that. But on your slide 14, it says through 309. Can you just tell us what other sections after 307 up to 309 would be added to this shift?
So thank you for the opportunity to correct that. That should actually be 304 through 307.
Okay, this slide 14 is actually through 307. Thanks for the clarification. That's all.
Commissioner Milliman.
Thank you, Chair. I remember a provision or ordinance, I'm sorry, I thought it was 889, that originally had language around installing a fence in a reduced clearance easement. Is it this one, and was that language removed?
So we have not proposed removal of that language. We did mention in the staff report that we did follow up with our current planning staff, and they confirmed that the intent was to specifically call out fences as items that could potentially obstruct access, and they were wanting that element to continue to apply.
Good, me too. Thanks.
Any other questions for staff? Well, thank you, Ms. Arendes, for your presentation. And I think we're ready now to open the public hearing. And I believe we have several people who want to testify on regarding 889. With a reminder that we're limiting testimony to 3 minutes.
Yes, we have two people signed up for 889. We ask that people start by saying their full name and location or address. We'll start with the name. Matthew Sprague, can you please come forward?
Yeah, my name is Matt Sprague with Pioneer Design Group. I'm a principal here. I've been doing land use planning in Washington County for 30 years. So I've seen a lot of changes to the code. I did submit a letter that has a substantial amount of detail in it in regards to my concerns for improvements to Ordinance 890. I don't want to confuse anybody because the staff, I think, is doing a very smart thing in moving some of these dimensional criteria to 890, whereas I thought it was going to be in 889. I'm not going to be available later today to speak specifically on 890. So I would request that you please review my letter in detail. In short, there's two things that we're looking for. One is I'm working on subdivisions that are zoned R5 and R6, and we're looking at middle housing. And if you have a whole bunch of parent lots all together in a row, currently, if you were able to get a land use approval for middle housing on 3 or 4 lots in a row, my recommendation is to allow those internal parent lot lines to have 3-foot side yard setbacks. My second recommendation is that there's a standard requiring a 25-foot right-of-way dedication in all cases. And I think that it probably would be more appropriate to add language into the ordinance that stated something like, unless otherwise approved by the county engineer. Because, for example, if you develop a subdivision and all of the streets are 100% complete and in place, but you come in for a middle housing land division, now you're dedicating more right-of-way for absolutely no purpose, because there are full improvements within the street already because it was just constructed. It would place property corners underneath sidewalks and or inadvertently remove additional land from lot areas and creating a no man's strip behind the sidewalk of 1.5 feet. And this is for local streets. So I thank you for allowing me to testify today. If you have any specific questions, I'd be happy to answer those. But otherwise, thank you very much.
Thank you, Mr. Sprague.
Yes, and next, I'm not sure if Nikki Munson wanted to testify.
I had a question for Mr. Sprague if he's still
Oh.
available. Sorry, Susan, for interrupting.
That's okay.
Chair Lockwood, may I ask of Mr. Sprague a
Yes,
question?
if he's still here.
Yeah, I'm here. Thank you.
Yes, I appreciate your participation and providing a written testimony, which I read and received. So thank you. I have a question. If, for example, in your example, you talked about existing kind of approved platted lots, and what I assumed, and correct me if I'm wrong on it, that you're saying if one person owned all 10 or 20 of them, and they wanted to apply that lesser interior side yard, you want provisions to allow that. What would happen if somebody owned 20 but sold 5 and had 15 remaining? Are you asking us to also allow the lesser setback between the 15 remaining and the 5 owned by some other random person?
No, regardless of ownership, I think this should only apply in the case where an individual has 2 or more parent parcels that are immediately adjacent to each other. The exterior lines of the outside parent parcels would always remain at 5 feet. But the interior parent parcel lines could then be reduced to 3 feet. So it wouldn't be relevant in the case of someone selling 5 and keeping 15. It would only apply to if that person had 2 adjacent parent parcels and applied for and obtained middle housing land division approval simultaneously. Without the simultaneous approval, then the 5-yard setback would apply.
One quick follow-up question, that's very clear. Since you're working with developers and planning, do you have an opinion if that would mean that your resulting interior lines would be would have a easement between them for obstructions?
Yes, I think in all cases where you have setbacks between units of less than 6 feet or less, that you do need to have those easements.
Okay, thank you for your testimony. That ends my questions, Chair Lockwood.
Thanks, Commissioner Will. I think that
Okay.
means we're ready. Yes, please go ahead, Ms. Aguilar.
Okay, and next, I believe Nikki Munson might want to testify in regards to 889 or 890.
So thank you for welcoming me. My name is Nikki Munson. I'm the Land Acquisition and Development Manager for Riverside Homes. And our address is 15350 Southwest Sequoia Parkway, Suite 320 in Portland, 97224. And I also understand that the issue that I'm here to discuss is actually being moved from 889 to 890. So I will speak briefly now, and if asked, I can speak again in the second topic here. But Riverside Homes has an approved subdivision where we would like to explore middle housing, and we would be utilizing the side yard setbacks that Matt Sprague with Pioneer Design Group discussed. He's our planner on this project. And I just wanted to let the Planning Commission know that it's our belief that if we can clarify the side yard setback issue for middle housing, and I should note that the subdivision was approved with 3-foot side yard interior setbacks, we assumed the same would be possible for the middle housing units. So if that can be clarified, the result on our subdivision would be an additional 20 homes, and we would estimate that those homes pricing would be reduced somewhere in the neighborhood, and this is a broad range, but at least $100,000 and maybe up to $200,000 less than if we stuck with our standard subdivision. So we're excited to be a developer who can utilize the middle housing code changes. And we'd like to be able to construct those interior lots with 3-foot side yard setbacks. Thank you.
Chair Lockwood, I don't believe that there's anyone else signed up.
Okay. All right, then we will close the public hearing and move on to discussion of ordinance 889. Commissioner Wellner. You're muted.
Shoot, 0 for 2. I wanted to disclose that Matt Sprague is my land use planner too. I work with Pioneer Design Group on almost all of my projects. And throughout this middle housing process, I've relied on Matt pretty heavily to review stuff alongside. And so we could bounce ideas off of each other and kind of think through how it affects the projects that we work on every day. This issue that he raised in his letter, and also the right-of-way issue, is something that kind of came up from some engagement that he and I had with planning staff on how middle housing is going to be implemented at the current planning level. We're kind of trying to figure our way through the process and figure out how we're going to be impacted by different views on different criteria. So that's how this came up through that. Matt and I are friends. We've worked together for a long time. And these are issues that'll affect my projects, but not any projects that I have going on right now. I'm also friends and have worked with Nikki in the past too. So just want to let everybody know that. And I do think that moving this to ordinance 890 is the best approach.
Thank you, Commissioner Wellner. Is there more discussion on ordinance 889? So Commissioner Wellner, I believe you're saying that you're comfortable with taking out the portion related to easements. Is that right?
That's correct, yeah. And I can make a motion to make, if you're ready.
Yeah, I'm checking to see if anyone else wants to speak about this, but I'm not seeing any hands. So I think we are ready for a motion.
So I move to recommend approval of ordinance 889 with the revised provisions to the CCI membership and CDC section 107-6 as shown in attachment A, the revised provisions for land divisions in CD section 602 shown in attachment A, and with the removal of the proposed changes to the side yard setback and maintenance easements found in sections 304 through, I believe that's supposed to be 307. Is that right? Okay. 307.
Okay. It's been, and your motion reflects exactly slide 14, is that correct?
That's correct.
Yes, thank you. Is there a second to Commissioner Wellner's motion?
I can second that.
It's been moved and seconded to recommend approval of ordinance 889 as provided on slide 14. Is there discussion of that? Commissioner Will.
I'd like to say that I appreciate staff's work and especially in support of, I'm in support of the changes to section 602. Thank you, Chair Lockwood. That was a comment I wanted to make in discussion.
Any further discussion? Okay, I'm not seeing any hands. Mr. Bovet, do I need to repeat the motion before we vote? You're muted.
Sorry, it'd probably be a good idea, although it was quite an extensive motion. I think you can summarize it because I think everyone knows what slide we're talking about.
Okay, I'll go ahead then. It's been moved and seconded to recommend approval of ordinance 889 to the Board of Commissioners with engrossment to revise provisions for CCI membership revise provisions for land divisions, remove proposed changes to side yard setback and maintenance easement language. May we have a roll call vote on that, please? Ms. Aguilar?
Yes. Commissioner Havner,
Yay.
Commissioner Milliman,
Abstain.
Commissioner Petrillo, Commissioner Petrillo. Okay, we'll move to Commissioner Wellner.
Sorry, yeah, that was a yes.
Oh.
It's- My mute wasn't going off for some reason.
Oh, okay, thank you.
Yes,
Commissioner,
yes from Commissioner Wellner.
okay, thank you. Commissioner Will,
Yes.
Vice Chair Dye,
Abstain.
Chair Lockwood,
Yes.
okay, looks like we have 5 yeses and 2 abstained. Motion passes.
Thank you.
Welcome.
I think we're ready to move on to our presentation on ordinance 890.
Okay, and Ann Kelly will give that presentation.
Have I been?
Yes.
Okay.
But now we can't hear you, Ann, if you are unmuted.
Sorry, I think you can hear me now. I'm having
Yeah.
trouble. There we go. Sorry about that. It wasn't showing me as a panelist at my end. But here we go. I'm here to present a presentation on the hearing for ordinance number 890. This relates to middle housing land divisions. Next slide, please. As an overview, this presentation will look at the context of middle housing land divisions. We'll look at House Bill 2001 and Senate Bill 458, state mandates, options, and prohibitions for local implementation. Then we'll look at some key community development code amendments we've proposed, potential engrossment changes, and our staff recommendation. Next slide, please. So in 2019, House Bill 2001 regarding middle housing was passed by the Oregon legislature, and it was intended to provide Oregonians with more housing choices in residential neighborhoods where single detached homes are allowable. Middle housing per the state is duplexes, triplexes, quadplexes, cottage clusters, and townhouses. And we made code amendments adopting state provisions for middle housing through ordinance number 885, engrossed ordinance number 885. After that, Senate Bill 458 came along in 2021. It was passed to allow middle housing land divisions for all types of middle housing. House Bill 2001 had previously provided for land divisions for townhouses only, but not through this new process. So per the state, middle housing land division is a partition or subdivision of a lot or parcel for middle housing. Its intent is to allow more people to own a home on its lot and expand access to home ownership. We must allow an expedited land division for all middle housing types. However, it's not a land use decision per statute. Middle housing land division provisions of the state are partly codified already through ordinance engrossed ordinance number 885, and the remaining requirements as well as some options are proposed as part of this ordinance number 890. Next slide, please. So the state does mandate a number of things. We don't have a lot of flexibility here. For process and timing, we have to issue a decision on the tentative plan within 63 days. That's about half the time for other land divisions. Those are maximum 120-day reviews. The appeal, if an appeal comes along, it has to go to a referee, which can be a hearings officer. It can't be somebody employed by the county. And that has to be decided within 42 days of the date that the appeal is filed. So that's also rather expedited. Any further appeal then has to go to the Court of Appeals because since this decision is not a land use decision, the Land Use Board of Appeals does not have authority. And also by mandate, the approval is void if the plat is not finalized within 3 years. Next slide, please. The state also mandates approval criteria. We have to approve a tentative plan that includes evidence of a middle housing proposal on the parent lot that's compliant with applicable land use standards and building code. Now that's a distinct application from the middle housing land division application, but the middle housing land division requirements of the state do call for compliance with the middle housing development application standards. So that's just one of the requirements for a land division. We also must approve it if it has exactly one dwelling unit per resulting middle housing lot. All of the buildings on the resulting lots have to be compliant with building codes relating to new property lines, the proposed middle housing land division property lines. Each unit has to have separate utilities. The proposal has to show easements necessary per unit for utilities, pedestrian access. We don't have to have vehicle access to every lot, and for common areas. And none of the buildings can be in a mapped natural resource area. So that's all prescribed by the state. And next slide, please. We do have some options though, and we have included these in our provisions. Senate Bill 458 allows but does not require us to require a number of things. We can require plat notes that specify the approval was granted through the middle housing land division process and limiting further division of the resulting middle housing land division lots. We can require a minimum right-of-way along the site frontage. We can require street frontage improvements, but only where a resulting lot or parcel will abut a street. We can't require that streets be provided where we might want to. And we can also require that the final plat be legalized before the new lots, to legalize the new lots before building permits are issued. Building permits can be in progress, but they can't be issued before plat recording. We are also allowed to allow concurrent applications for both building permits and a middle housing land division. And we do propose all of these things in our standards. Next slide, please. The state prohibits us from requiring certain things, and these include a hearing for the decision, except in the case of an appeal. We can't require minimum lot sizes or street frontages for resulting lots, except for townhouses, because HB 2001 did allow us to provide for those as part of our middle housing development provisions. We cannot require vehicle access, parking, or driveways for individual lots. And we can't apply approval criteria that's not otherwise specified by Senate Bill 458 or House Bill 2001. Next slide, please. Key amendments that we are proposing are intended to facilitate preparation and timely review of applications and consistent interpretations by staff, applicants, anyone who touches the application during the review process. And together, the two ordinances, ordinance number 885A, which has already been adopted, and ordinance 890, this ordinance, include all of the mandated and allowed provisions of the state for middle housing land divisions. Through the last ordinance, we adopted a definition of middle housing land divisions as expedited division of a lot or parcel into separate lots or parcels for individual middle housing units. We provided for only one unit per resulting lot, and it has to be middle housing. We informed that the property lines of middle housing lots would be subject to setbacks. And we provided exemptions from neighborhood meeting requirements and circulation requirements that apply to other types of land divisions. We also provided right-of-way and public improvement requirements as part of a engrossed ordinance number 885A. Next slide, please. So moving on, as part of this proposed ordinance 890, we propose to clarify the middle housing land division definition. We make distinctions from other land divisions. We clarify that this is not a land use action. We provide standards for clarified standards for mixed solid waste and recycling and for street trees in relation to middle housing land divisions. We clarify exemptions from screening and buffering requirements and on-street parking. And we also clarify certain provisions in minor ways that otherwise apply to middle housing. We are also adding review and appeal procedures and submittal requirements. We're adding the requirements for separate utilities, except in cases where clean water services would allow shared elements of a storm or sanitary system. And we are requiring those plat notes I mentioned that specify the decision was through the middle housing land division process and that no further division of the lots is allowed. So next slide, please. Moving on, we have a couple of issues we just wanted to discuss that were partly discussed in the last hearing, before the last hearing. There is the setback issue you just heard about. It becomes a problem when there is a standard land division in advance of a middle housing land division, or middle housing land divisions plural, I should say. So this is not something that was contemplated by the House bill or the Senate bill for middle housing or middle housing land divisions. But it's certainly something that we're seeing a lot of as we get real cases. So when you have a standard land division like this one here, there's an existing standard that applies to side yards that are not adjacent to a street. The standard is actually 5 feet, but you can reduce it not just to 3 feet as many people understand it to be, but to as little as 0 feet, as long as the yard abuts the side yard of another lot, and that other lot is also in the site, the development site. And as long as there's at least 6 feet of building separation maintained and an easement is provided, allowing reciprocal maintenance activities. So this graphic shows a standard land division. You can see where you can reduce internal yards. Those might be each 3 and 3, or 2 and 4, 1 and 5, 6 and 0. Those can all be reduced. The ones abutting offsite land have to remain at the standard of 5. Next slide, please. This becomes a problem when after a standard land division occurs, creating a number of standard lots, middle housing land divisions are subsequently proposed on those standard lots. Each of the new standard lots is a distinct site for purposes of a middle housing land division. We talked about how the state defines the middle housing land division as tied to a lot or parcel. So under current standards, an applicant could not reduce those side yards, some of the ones that we just showed as reduced in the prior slide where the original land division occurred. So now they could reduce the side yards internal to each of these middle housing land division sites, A and B, each is a distinct site, where they're creating that new lot line through a middle housing land division. They can no longer reduce the lots that used to be adjacent on-site lots within the original subdivision. Now they're off-site when you compare lot, site A to site B. The middle section that's yellow represents land abutting off-site side yard area. So you can't reduce those. And additionally, other land within the original subdivision becomes off-site to this middle housing land division site B. That's creating some problems for developers who want to be able to achieve maximum number of units and reduce cost. Next slide, please. So we are proposing a solution that would allow reductions in these areas shown in green. And this would be where abutting middle housing land division sites, for example, A and B here shown in orange, where middle housing land divisions are proposed concurrently for both of those lots by the same applicant, you could reduce that middle section, the side yards in that middle green section in that case. We're also proposing that you could reduce the area shown in green at the bottom of site B. That would be land in the original subdivision area. You could reduce it as long as it's still controlled by the same applicant. So it goes maybe a step further than what was discussed in the last hearing. And we are developing CDC language to address both of these allowances. Next slide, please.
I'm sorry, why is the yellow area not allowed?
Could we go back to that slide, please? Are you talking about this slide, Commissioner Petrollo?
Yes, the lot 1 on the top, site A on the top.
So that is offsite land that is not in control of the same applicant.
Okay.
Has
That's
always
fine.
been offsite land.
Thanks.
Okay, next slide, please, then. So now we're moving on to the right-of-way and easement issue. We also heard about this in testimony that was submitted, and I'll just give a little bit of background here. For type 2 and 3 development, a road subclassification that applies to a site frontage is not necessarily known at the time the application is submitted. It's determined as part of a discretionary review, a type 2 or 3 review, through an engineering review. And for certain road subclasses, improvements can be allowed partly in easements through that discretionary review. State law, though, requires that we apply clear and objective standards for housing and, of course, middle housing. So our adopted CDC standards for middle housing allow a type 1 process with clear and objective right-of-way minimums specified in the CDC. And we discussed this as part of the engrossed ordinance 885A hearings process. So now, along some sites where middle housing is proposed, we are finding that frontage improvements are already built to ultimate county standard, and they exist largely in right-of-way, but some are partly in easements. And they've been allowed to be in those easements through that type 2 or 3 development review through a discretionary process. Some middle housing developers are suggesting that additional right-of-way to meet the currently adopted middle housing standard is not needed in such cases, and so we shouldn't require it. Next slide, please. So I'm just going to run through potential changes to address these issues that I just talked about. For the setback issue, we would propose to modify the non-street side yard setbacks of district standards in Article 3 to clarify existing language regarding required maintenance easements where a setback is reduced. And this pertains to the amendments transferring from, what was it, 889, I believe, the past ordinance, into this ordinance number 890. We would also propose, and this is something new, to change that standard non-side yard setback requirement that is currently 5 feet to 3 feet, and still allow reductions as long as that 6-foot separation and 6-foot maintenance easement are provided. We would also look to resolve the noted issue that occurs when we have a standard land division and then a subsequent middle housing land division, to allow minimization, allow reduction of more of the side yards, as we just discussed. Next slide, please. And then regarding the right-of-way issue, this slide shows existing language for type 1 single detached dwellings, certain expansions of those, and for middle housing. It specifies minimum right-of-way widths of 25 feet to center line for a local street, 30 feet for a neighborhood route, 37 feet for a collector, and 45 feet for an arterial. We would propose to add an alternative where if road improvements are built to ultimate county standard and they exist in a combined right-of-way and easement with the totals, those above requirements there, that would also suffice. We would not require additional right-of-way to meet what's shown on this slide. Next slide, please. So our recommendation is that you conduct the public hearing and recommend approval of ordinance number 890 to the Board of Commissioners with engrossment to make these changes we've discussed in the presentation. Thank you very much.
Thank you, Ms. Kelly. Are there questions from commissioners? Commissioner Wellner.
Thank you, Ann. I think both of those fixes are good fixes. I did have a couple of additional questions. So it's not in ordinance 890. The language that I'm referring to is what's gotten drawn out of ordinance 889 and moved to 890. But it's the section that speaks specifically to the setback. And I think that it says explicitly that the setback is 5 feet except, and this is for the middle housing setbacks in each one of the zones. Says 5 feet except where lots or parcels are approved through a land division to have adjoining interior side yards less than 5 feet. That language where it says except for where it's been approved through a land division is going to be problematic, because you're going to have middle housing that hasn't gone through a land division where the expectation is 3 feet. So that you'll have to look at making an amendment there too, I think.
So where you have middle housing that is not going through a land division, those internal areas between the sides of buildings are not considered setbacks. Those are just subject to the minimum 6-foot building separation requirement. And that building separation requirement will translate directly if someone then comes in and does a middle housing land division with the reduced side yards at 3 and 3 or 2 and 4, whatever, and provides the maintenance easement.
So then you may want to add that, a quick statement pointing people there to that section of the code, the middle housing section of the code that speaks to the 6 feet, because it's confusing to me reading this. I mean, it says for middle housing that the setback should be 5 feet.
So this is all, but see, that's not considered a setback when it's not to a property line. And all of these setback provisions are included in the same location in Article 3. I believe that the building separation requirement is in proximity as well there, but I will make sure of that.
Yeah, it's just under 3047.1. Look at that and relative to all the other districts too, because I think it's a little confusing. If you do just change the default side yard setback to 3 feet, I'm assuming you're going to have language then that only requires the easement when you don't have 10 foot of building separation.
We're just thinking of requiring it as long as there is the 6-foot separation.
Okay. So
Or
when they're
requiring that 6-foot separation.
the setback is 3 feet. But when you have 6 foot of building separation, you must have an easement, something, it'll be much more eloquent than that.
When you have as little as 6 feet, likely that way.
Okay, and then as I commented on 889, and I know you guys are already doing this, but just to reiterate that this change under the middle housing setbacks in each district also needs to be included in R5 and R6.
Yeah, we're aware of that. So we will be changing it for middle housing in all of the districts.
Great. And then the last thing was a curiosity. There's this on page 35, it carries over to 36 of the staff report. It says the type of middle housing approved on the parent lot or on the parent parcel shall not be altered by a middle housing land division. For example, a unit approved as a cottage or detached middle housing unit, triplex or quadplex unit shall remain such after a middle housing land division. It shall not be considered a single detached dwelling as defined under section 106. Can you explain why that's necessary? I'm assuming that's to keep more middle housing from being built on a parcel, but by default, when you divide it onto its own lot, it is a single family home. It's not.
Effectively it is, but that provision that you just read comes from state language, and the middle housing land division provisions allow for exactly 1 unit per lot. So you would not be able to do an accessory dwelling unit, for example, with a detached duplex unit or triplex unit.
Okay.
It comes down to allowances that relate.
Yeah, I was just curious as to why. That's it. Thank you.
Mhm.
Commissioner Will.
Yeah, thank you, Chair Lockwood. I have a question for staff on the report. In the graphic where staff show the second image showing proposed changes to allow the setbacks on property lines in the same ownership, I think was the word, or controlled by the applicant. I don't know if we could turn to that slide. I won't say it's slide 12, but I can't recall. Commissioner Petrillo asked a question about it. Yeah, this slide. So it makes total sense to me what the staff is suggesting to meet the on the ground situations that developers are experiencing, and property owners are experiencing, such as allowing a reduction between lot 2 of site B in this graphic and lot 3. Commissioner Petrillo asked for clarification why the yellow area on lot 1 was not allowed, and that was because it was not controlled by the applicant. I want to ask the staff if to clarify, you know, in the text here it's applicant like singular, maybe there's like multiple applicants. If lot 3 was sold to somebody else, making it you know, not controlled by the applicant, could the applicant then get that owner to sign the application, and therefore they're joint, it's a joint application, and the same would go for the property above lot 1 shown here as offsite land. If that property owner signed the application, could that turn a yellow into a green?
It potentially could. I mean, we see things, I mean, property line adjustments will require signatures by both parties. Anything affecting a neighboring property, you know, directly, not just an impact, but affecting the land area, we see that. So it's possible that that could occur because that would make, that actually would make the offsite land part of the application.
Right. I want to make sure that that is somehow watched out for when we use words like controlled by. I mean, I don't know the definition of controlled by, but I'm assuming if the property owner to the upper side of lot 1, you know, owns a 5-acre piece of property, and that's a giant forest, and their house is on the other side, they might be more than willing to allow lot 1 to reduce its allow a reduction in its side yard. So we should I think we should encourage the site A owner to seek out conversation with the neighbor and seek the neighbor to sign the application if an exterior boundary is needed to be 3 feet. If that exterior property owner would allow that or approve that and sign the application, then that should effectively make it controlled by the applicant. I think that's important.
This is not, what you raise is an interesting issue, but it's not one that's unique to middle housing. The standard we're discussing has been in the code since probably 1998. It does require what you're seeing there in that yellow already for any kind of land division. And so in effect, you know, since 1998, the neighbor next door could make themselves party to the application and allow the reduction by doing so. But
you may not see it very often because, you know, it's hard to get neighbors to agree to such things that might impact them, but that's great.
Well,
that it
for
sounds like it's
one
allowed.
thing, for example, once they're part of the application, they're also part of the, they're part of the requirement for right of way and so forth. But I have to get back to this middle housing land division application, because you're talking about a standard that applies to both a standard land division and a middle housing land division. For middle housing land division, you can't make that other property part of the development site, the application, because the state says that a middle housing land division is division of a lot or parcel, not a compilation of lots or parcels like we might see with other land divisions.
Great. Thank you.
Are there further questions for Ms. Kelly? Well, we've been in session for about 90 minutes, which is when we usually take a break. So I'm going to propose that we take our 5-minute break now and return at 3 o'clock. And Vice Chair Dye, I see you have your hand up.
I just want to let you know I will not be returning after the break.
Yeah, thank you for letting us know. All right, without objection, we will break for 5 minutes. Commissioners who have returned, please turn on your camera. Thank you. And Mr. Bovet, we need a roll call. Is that correct?
Chair, I don't think you technically need one, but I think it'd be a darn good idea with so many coming in and out and then us losing the vice chair here. So I think it'd be a good idea.
Okay, thank you. Ms. Aguilar, may we have a roll call, please?
Yes. Commissioner Havner,
Present.
Commissioner Milliman, Commissioner Petrillo,
Present.
Commissioner
And I'm just
Wellner.
going to note that, oh, there we go. I think Commissioner Milliman was in the participants or attendees, so it looks like she's here now.
Okay.
Mr. Wellner's present.
Commissioner Will,
Present.
and Chair Lockwood.
Present. Thank you.
Okay.
Oh, sorry to interrupt. We have a quorum, correct?
1, 2, 3, 4, 5. Yes, and as soon as Commissioner Milliman gets, Commissioner Milliman, looks like she is,
Present.
yes, we do have a quorum.
Thank you. All right, I think we're ready now to open the public hearing on Ordinance 890. Do we have anyone signed up and present to testify?
Okay, in advance, we did have Matt and Nikki, but they had said that they had testified in 889.
Okay.
What we'll do is bring Jody forward.
I think Nikki wanted to testify as well on this ordinance.
Yes, and we'll let Jody go first and then Nikki second.
Can you
So-
hear me?
Yes, we can.
Hi, thank you all very much for your time. This is the first meeting of this sort that I've attended. My husband, my daughter, and I have created an LLC, Dan Homes LLC, and we're in due diligence on a property which appears to be the most brutal territory on the urban growth boundary between unincorporated Washington County and the city of Cornelius. And our goal is to do a cottage cluster. And obviously with this ordinance, it looks like it won't be in place if it's approved until January 2023 on Washington County's side. Is that correct?
Chair, would you like us to
Yes,
answer?
please. Yes, please.
If this ordinance goes forward and is engrossed, it would be at some point, probably in January, yes, that the board would consider it for approval.
Okay, my other question is on section 60610 on B. I had a question. It says only one dwelling unit is permitted on each lot resulting from a middle housing land division. And then it says accessory dwelling units are not permitted. When it's a cottage cluster, because we've not done this before, but from all of the reading I've done, it was my understanding that you have one lot and the cottage cluster exists on that one lot. But this verbiage indicates, say for instance, on this particular lot, if you're going to put 4 units, because I know middle housing is a minimum of 4 units for the cottage cluster, but hypothetically, the language here sounds like we would need to divide it 4 times, which would not reach, then you couldn't engage the very middle housing purpose that you are attempting to do if you divide all of them. So can you please clarify that?
Ms. Kelly, did you want
Thank
to
you.
answer?
Sure, yeah. So Ms. Dan, how do you, I don't know how you.
It
pronounce
just
that.
sounds, it's Deanne. It sounds like the first and
Deanne.
last letter. Yes.
Okay, Dan, thank you. I believe you're thinking, okay, let me just separate the two different actions. In June, we adopted an ordinance that includes standards for middle housing. I believe that speaks to what you're thinking of. I mean, it's for middle housing on a single shared lot without a middle housing land division. A middle housing land division is a separate action. You don't have to divide the property, but you can. The middle housing land division standards are partly adopted, and we're adopting the remainder of requirements through this ordinance ultimately. But you do not have to divide any kind of middle housing except for townhouses.
Okay. Okay, and thank you for that clarification. I do have one more question. Is that okay?
Yes, you've got time.
Okay, I just want to make sure everyone has time. So September 7th was the first time we went to Washington County offices and City of Cornelius offices in regard to this lot of land. City of Cornelius wants us to annex and rezone on their side, but it's been really ominous what the expectation is from ODOT. ODOT just keeps drafting a document for us to donate land, but they are not saying how much. But my question for you guys is, it appears if you talk to City of Cornelius that we wouldn't have an option to develop on the Washington County side, but the more I read, the more I look into it, it's on the unincorporated Washington County side. And when I looked at feasibility of both sides, it would make more sense for us to stay on just Washington County side.
So we're
Madam
coming
Chair.
close to time, and
Madam Chair,
I
this is more of a
yeah.
pre-application issue.
right.
Yeah,
We're going
we
to
have a
conference.
yes, we've done one already and have not obtained helpful information. Our second one is scheduled with City of Cornelius next Tuesday with my land use planner. The question is, could we, instead of annexing and rezoning in City of Cornelius, if we are inside of the urban growth boundary, because it's the only undeveloped lot in that area, on the north side of TV Highway and Baseline, could we stay and develop middle housing if this is approved, or even if it's not approved, to develop it on the Washington County side and not have to annex and rezone into City of Cornelius? Is that an option for us?
We're still outside the scope of this ordinance at this point.
Yeah, Ms. Cherniak, did you want to respond?
Sorry, I would echo Commissioner Petrillo's comment that this is outside the scope of the ordinance. I did just see an email from Ms. Deanne today, and we can address her concerns outside this. So expect some contact from long range planning, Ms. Deanne, later today or tomorrow.
I spoke with Brian Robb earlier today.
So I'm sorry I have to interrupt, but this is outside.
It's in regard to middle housing development. I don't understand how it's not relevant. I've just been put off for 2 months trying to get answers. I've been really patient. And I received an email from Ann on October 7th saying somebody would be in touch with me, and never heard anything. So today I reached out to Brian Robb.
I think you can be assured that you'll hear from Ms. Cherniak.
Okay. Thank you.
Thank you for coming. Any further testimony, Ms. Aguilar?
Nikki Munson, if she wanted to, and her hand is also raised.
I would just like to add to the testimony that I gave earlier that I appreciate staff's recommendations and discussion concerning Ordinance 890, and we support what has been shown and continue to look forward to working with the county. Thank you very much.
And Chair Lockwood, no one else has signed up. Would anyone in attendance like to communicate to the Planning Commission on Ordinance 890? And if so, please indicate by raising your virtual hand. Seeing no one else, we can move on.
All right, we're ready now. I'll close the public hearing and we're ready now for deliberation on this ordinance. Does anyone have any comments? Commissioner Wellner.
I just wanted to reiterate the same disclosures I made on ordinance 889, since they kind of have some overlap there. I'm just making the same disclosure statements. I am supportive of the approach that staff has outlined on the fixes that they identified, the right-of-way issue and the internal setback issue. I would like to see the language. I don't think we have something that we can approve today because we haven't seen the actual draft language yet. So, or recommend an approval today. So, but the approach that they've outlined is something I'm supportive of, and the ordinance itself, I am as well.
Commissioner Will.
Thank you, Chair Lockwood. I seem to understand that the staff's recommendation is that we move the language in the examples in the staff report for ordinance number 889 and address them as part of 890. So I also have some hesitation to understanding exactly what we would be approving with 890, since there's a little bit of bleeding between the two. So I'd love staff to help us understand that better. Thank you.
Commissioner Petrillo.
Well, I think the fork in the road is that we could either move forward with a motion of recommendation with the outline of what staff is going to engross, or we could continue it, the ordinance to the next meeting to have the engrossment language in place to review and recommend. I think those are the two choices we have. I think further deliberation of staff or clarification of what was already discussed isn't necessary. I think it's just a matter of taking one action or the other. If it's the former, then perhaps we would need clarification from staff. I favor the latter, which would be continuing action until our next meeting, so that if it's possible, the staff would have the engrossment in place to review. That said, I guess I'd like to know from Teresa and or Ms. Kelly if that works within their timeline and plan to have this adopted. What would the latter work within, having endorsement language in place by next meeting?
There is time prior to the board hearing for us to come back to the Planning Commission. I think that what we would have is our best work to that point for the language. And so I think there might still need to be some refinement after that point, but we would have much better language than we do at this point. And so just with the understanding that it could slightly tweak to be a little bit more clear, but we would have basically the language. I think we could do that for the next meeting.
I'm not going to preempt action for everyone else. Others might want to speak to how to proceed, but I would favor the latter then, of continuing to see a 90% endorsement language at the next meeting, just because, well, I'll give the reasons afterwards, but so if there's anyone else that wants to comment on how to proceed.
Any further comments?
Well then, I'm going to, Chair, could I be recognized again?
Yes, go ahead, please, Commissioner.
I wanted to say, I really also want to applaud staff for addressing or helping address these kinks as we go through this process of implementing the middle housing ordinance and seeing it happen. I also want to thank Riverside Homes folks, Ms. Munson and Mr. Sprague. Mr. Sprague, I think, laid it out very well, the need, the intent of middle housing ordinance. And then we get down into the technicalities when we're like, oh, well, that wasn't contemplated, although it was, in my opinion, the intent was to encourage. So we saw this with North Bethany umpteenth times where it was, the plan was adopted, and even now we're still tweaking because we don't have all of the information. I mean, it's just the way the process works, particularly when you're dealing with a development code. So thank you for being quickly responding to this issue as it came up. And I think what you're recommending or what staff's willing to consider as engrossments is really a leap in the right direction toward a successful implementation of the middle housing ordinance and public goal, and it's a win-win for developers and for the state and the county. So
Any other comments? Commissioner Will.
I tend to prefer, I think, as I've heard, to continue the discussion until we see different documents. I don't think I saw in the staff report for 890 at the end, maybe it's somewhere in the middle, recommended language for making a motion. So that would also make it a good reason to wait. But if that's going to happen, if the staff is going to be directed by us to come back and give us more information, I may be in the minority, but I really don't like. I know that, I guess you call it current planning staff, has commented to long range planning staff that they really want the word fence inserted in there to start creating a list of things that are structures. I just personally feel that it's unnecessary to list or insert examples of types of structures. Because then next year, we're going to have to add flagpole, and the year after that, we're going to have to add bird bath. I think it says structures. And so if there is a definition of structures, then we don't need to, that includes fences, we don't need to add fence. So that's my personal opinion. And then I also want to point out there is the word could in that language. So like structures that could inhibit access or whatever. So is that something the staff wants to just think about? Because a fence could be an obstruction, or it may not be if you can put a ladder over the top of it. So a flagpole could be an obstruction, but maybe it's got a adjustable base. You can take the flagpole down when you need to, but when somebody wants to build something. So I just thought it was interesting that there's this the word could in there that doesn't make, is supposed to be a clear and objective standard, because that word might make it not very clear and objective. And is there a definition of structures in the code? And if so, are fences in it? So those are things for clarification I don't know the answers to. Thanks.
Commissioner Milliman.
Sounds to me like Planning Commission is fielding questions and issues around fences. So it would make complete sense to me to add the language, and I'm supportive of it. Just want to put that out there. I mean, it's an issue that needs resolution somehow because it continues to come up in the county. So this seems like a way to resolve it.
Any other comments?
I would I'm sorry, I'd like to be recognized, not by my cat, but by the chair.
Commissioner Petrillo.
Sorry, he doesn't, he's an annoyance sometimes. Okay, I'd like to, I move that Planning Commission continue. I move that the Planning Commission continue deliberation on Ordinance 890 to the following meeting, which is November what? If someone could.
That would be November 16th.
November 16th, that it, we continue it in that staff provide us with some engrossment relative to their suggestions for changes. 890 relating to side setbacks and street improvements.
It's been moved that we continue consideration of ordinance 890 to our next meeting, November 16th, and that staff provide language around site setbacks and street improvements. Is there a second?
I'll second it, Commissioner Milliman.
Thank you, Commissioner. It's been moved and seconded. Is there discussion? I'll comment that this makes a lot of sense to me. I'd like to see the further development of the language so we can understand better exactly what will be in the ordinance. Any other comments? Commissioner Will.
My comment is that we heard tonight from the public through some testimony by a couple parties that they want to see that something addressed for existing subdivisions or properties that are in common ownership or common group control. It's concurrent applications, so I assume that that will also be addressed.
Sorry, that would be part of the side setback conversation and language.
Any further discussion of this motion? All right. I think we can take a vote. We're ready to vote on the motion to continue our consideration of ordinance 890 to our next meeting, November 16th, including asking staff for the language on changes to the ordinance around site setbacks and street improvements. Could we have a roll call on that, please, Ms. Aguilar?
Yes, Commissioner Havner. Commissioner Havner,
I apologize. Yes.
Commissioner Milliman,
Yes.
Commissioner Petrillo,
Yes.
Commissioner Wellner,
Yes.
Commissioner Will,
Yes.
Chair Lockwood.
Yes.
That would be 6 yeses. So the motion does pass.
Okay, thank you.
Welcome.
We're ready to move on to consideration of minutes for October 5th. Are there any corrections to offer or amendments to the minutes for October 5th, 2022? I have one on page 3. The bullet point number 3 under PC discussion and comments. It says hybrid meetings could help accessibility for PC candidates who may otherwise not be able to serve on the PC due to time or other constraints. So I'm proposing that we insert the word travel, not be able to travel, not be able to serve on the PC due to travel time or other constraints. I think that's a little clearer and reflective of our discussion. Anything else? All right. Is there any objection to approving the October 5th, 2022 minutes as amended? Seeing none. Commissioner, Ms. Kelly. So maybe she.
I'm sorry, that's not a new hands up.
All right, okay.
Thank you.
All right, very good. So I think we have just approved the minutes for October 5th. Without objection. All right, the next item on the agenda is Planning Commission announcements. Does anyone have anything they'd like to announce to us? Share with us? I don't see any hands. Yes, Commissioner Wellner.
Not really an announcement, only to share that the market has gotten very challenging as of late. So I've just seen a lot of projects fall apart, kind of interest from builders go way down, and it's primary for both multifamily and single family projects. And until interest rates come back down, I think activity is going to be pretty slow. There's just with rates where they're at, it's really difficult to build large projects. And people that have 3% interest rates aren't super motivated to sell their house and move into a 7% interest rate house. So we'll see how long it lasts, but right now it's definitely different than it was 12 months ago.
Thanks. Commissioner Petillo.
Yes, thank you, Chair. And Commissioner Wellner, I'm sure the Federal Reserve Chair is very happy to hear those comments, because that's exactly what he wants to see happen, right? He's trying to restrict policy interest rates to slow down inflation. So that it's a very odd situation we're in. So what I was going to mention two things. One was a follow-up on our conversation about in-person or hybrid or in person or remote versus in person, however you want to figure it out. I think we need to, I want to just emphasize from my perspective the importance of doing in person. I do think that I'm not going to be around for it. So it's like parting advice to some degree, but it's convenient to have Zoom. It makes it available. It makes it accessible or easier for certain planning commissioners to participate in as citizens to have it as Zoom or hybrid. But there's also a loss. We're social beings. And there's a loss that's hard to describe, but that is, I think, material, and that is worth it to be in person as much as we can. So I hope they'll, as you move forward into the next year with new members, that I think it's convenient, but convenient always doesn't create necessarily effectiveness or. And I just think that it's very easy to default to say, well, it's just easy. And I think, yeah, there's an effort that has to be put in. And I'll say this with some reservation, which is, if it's too much of a strain on people to participate in person, and maybe the Planning Commission is not the place for them, because it really isn't that important of a commission that I think is worth doing in person. So that's one. Two is I did listen to the transportation deliberations at the Board of Commissioners over one Cornelius Pass extension, and boy, it seems like a lot of time and effort has been put into these road extensions to, and then nothing. Few of them, if any of the three that I'm thinking of, moved forward, and I don't know what to make of that, other than I think going forward, before both planning commissions engaged, and even more so before all that staff time is engaged, that we have some alignment with goals and objectives versus seeming like, well, this wasn't really what the board members or commissioners wanted to move forward. And I think that must be very frustrating for staff, and frustrating for me too, just because I was questioning why we were doing it anyways. And then thirdly, and you don't need to respond to that. I mean, staff doesn't. I am concerned as a planning commissioner and as a citizen that the county, we're going to, like many organizations and businesses, I sense the county is facing staffing issues with retirements, some pandemic or related, some not, just people aging out, and long-range planning and current planning or permitting, and even traffic engineering or transportation. I'm just hearing that there's gaps that seem to be in staffing and resources, and I don't, in the past when I've noticed it, it says the response was, well, we're supposed to be self-funded. It's so important. The work is so important that you do, this department does, that for the county, the unincorporated county, that I think it has to be prioritized more. And I realize it's not necessarily for staff to do that, but at some point, maybe before, I rotate off, I recommend a motion or a resolution to the board to really try to address some of this before it hits a critical point. And perhaps my observation's incorrect, but that's kind of what I've heard from different people at different levels. And if it's not true, I'd be happy to hear so.
Any other commissioner announcements, comments? Commissioner Wellner.
I'll be quick because I know we have stuff to do, but in response, Jeff, things have improved. So things are still slower than they were historically, but things have definitely improved, which is, I mean, I've seen turnaround times on certain things that are half of what the worst case scenario was. And it's not that they're perfect, but they're getting better. And action is happening to make them better.
Any more? Our next item is adjournment. Is there any objection to adjourning? Seeing none, we are adjourned. Thank you.
Thank you.
Bye, everybody.
Bye-bye.